Like all who have business before her ladyship, the Right Honourable Chief Justice Tun Tengku Maimun binti Tuan Mat, and your lordships, draw near and give your attendance. My lady and my lords, this is in the matter of the Sabah and Sarawak opening of legal year 2023, holden at MIRI, Sarawak.
Invite Mr. Gurpreet Singh Sandhu, the President of the Advocates Association of Sarawak, to deliver his speech.
The Right Honourable Tun Tengku Maimun binti Tuan Mat, the Chief Justice of Malaysia, the Honourable Tun Muhammad Rao Sharif, former Chief Justice of Malaysia and member of the Judicial Appointment Commission, the Right Honourable Tan Sri Dato' Amar Abang Iskandar bin Abang Hashim, Chief Judge of Sabah and Sarawak and Acting President of the Court of Appeal, the Honourable Dato' Muhammad Zabidin Muhammadiyah, Federal Court Judge, also covering the duties of the Chief Judge of Malaya, Honourable members of the Judicial Appointments Committee, Honourable Judges of the Federal Court, Court of Appeal, High Court and Judicial Commissioners, Honourable Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, Honourable Solicitor General 1 of Malaysia, the Honourable State Attorney General of Sabah, and the Honourable Deputy State Attorney General of Sarawak, President of the Sabah Law Society, representatives of the Malaysian Bar, Law Society of Brunei Darussalam, Dato' Banda of MIRI, heads and representatives of the federal and state departments, international organizations and agencies, judicial and legal officers, members of the bar, members of the media, and legal publishers. Distinguished guests, ladies and gentlemen. A very warm welcome I bid to all whom have taken valuable time to be with us here in MIRI, Sarawak, on occasion of the opening of the legal year of the High Court of Sabah and Sarawak. As a Tuai Rumah, it is apt that I am given the opportunity to address my ladies and my lords, first to extend our welcome and then to commendations to our guests. There are few pleasures enjoyed by the President of the Advocates Association of Sarawak, and to be upstanding here today to address my lady and my lords is definitely one of them. This is especially so on occasion of the opening of the legal year 2023 being held this year in MIRI. It is for me, as a local Mirian, a very familiar place to be in. As an advocate primarily practicing in MIRI, I am profoundly familiar with this courthouse and especially this courtroom where the resident judge, Yang Arif Tuan Din Wendeli, presides. The last OLI was held here in 2018, and in my view, it is quite apt for the opening of the legal year to return in its usual format right here in MIRI, as we feel that we had set the benchmark for such events in 2018. Since then, we have noted that each OLI has come to be grander than the previous years, and for this year, we hope that it will be no less. At this juncture, it would be remiss of me if I did not highlight the tremendous efforts and working relationship of the Advocates Association of Sarawak and the Sarawak judiciary, which has cultivated to a successful OLI. Allow me to convey the association's sincere appreciation towards the PMTSS Tuan Nixon Kennedy Kumbong, PM Rens Puan Dayang Elin, and the Pengarah Mahkamah Sarawak Tuan Steve Litikos and their committee for working very hard to ensure that this OLI is nothing less than a success. To the Advocates Association of Sarawak MIRI branch, under the chairman Mr. Lee Jinwen and his committee, nothing less than the best was expected from you, and I'm pleased to see that you and your committee's hard work has come to fruition. We must also record our gratitude to Yang Arif Din Wendeli for being available to us at all times and whom has indulged us with his advice and guidance. I will be the first to admit that the preparations for the OLI was not always smooth sailing. Nonetheless, we celebrate the fact that we are able to make decisions with consensus and to achieve the common goals of the OLI. This, of course, is a mature relationship we enjoy with the Sarawak judiciary. My lady and my lords, we have arrived in the year 2023. We learn from yesterday, live for today, and hope for tomorrow. While we direct our attention towards the future that lies ahead of us, we must recognize the difficult past that we had endured, a past where we had lived with the COVID-19 pandemic. In the span of the last 2 years, and despite crippling lockdowns and restrictions, we celebrate the fact that the courts had not halted the wheels of justice. The pandemic has affected our lives in unprecedented ways. However, there was some silver lining, as the pandemic did bring about conducive changes by the way of acceptance of technology to the way we practice law. An example of this is, of course, the project for video conferencing module called VCOS, which is presently used in courts. We must pay tribute towards the judiciary, the court staffs, advocates, and other stakeholders whom have embraced the positive changes made to legal practice, ultimately ensuring that the wheel of justice continues to spin unencumbered by the circumstances faced globally. My lady and my lords, Malaysia Agreement 1963. Upon the advent of the Dewan Rakyat giving recognition of the MA 63 under the definition of the Federation, Articles 1, 2 and Articles 160 sub 2 of the Federal Constitution have been amended and now gives express recognition to the Malaysia Agreement 1963 in the Federal Constitution. Since then, while we acknowledge that there has been some positive steps taken by the government, the association associates itself with the view that we can do more to remedy the fissures of the terms of the Malaysia Agreement 1963. Of particular interest to the association are the following amendments which ought to be made to the relevant laws. The first is the amendment to Article 46(1) of the Federal Constitution to reflect the precision envisaged in the Malaysia Agreement that not one territory would have 2/3 majority in the Dewan Rakyat. Second amendment would be to the Court of Judicature Act 1964 to reflect the position that there should be a judge with Borneo judicial experience sitting on the appellate panel hearing appeals which originate from Sabah and Sarawak. And the third would be amendments to Article 122AB of the Federal Constitution to restore the powers of the head of state of Sabah and Sarawak to appoint judicial commissioners. As of late, there have been reports suggesting that Sarawak should compromise on certain rights under MA 63, rights which includes Sarawak's autonomy over immigration matters. The association notes with much relief that the state government, through the Yang Amat Berhormat Premier, had taken the position that Sarawak will not compromise when it comes to the autonomies granted to the state as enshrined in the Malaysia Agreement 1963, especially relating to the state's control over immigration. By this, the exclusive right of audience for Sarawak advocates would be well preserved. Sarawak should not yield on any terms assured under the Malaysia Agreement 1963. My lady and my lords, the rule of law. The rule of law in Malaysia is guaranteed in the Federal Constitution as well as other federal and state laws. There's little doubt that fundamental to the rule of law is the independence of the judiciary and its institutions. Judicial independence is particularly of such importance as a free society exists only so long as it is governed by the rule of law. The rule which binds governors and the governed, administered impartially and treating equally all those who seek its remedies. Therefore, the rule of law is a fundamental principle that ought to concern not just lawyers, but also every citizen, as it is so fundamental to our lives. The principle that Malaysia is a government of laws and not of men should be embedded within all layers of society. The term rule of law covers a number of important principles which revolves around judicial independence, access to justice, and legal representation. I will seek to highlight a few points which require some attention. My lady and my lords, on the issue of judicial independence, we celebrate the fact that judiciary's independence is guaranteed under Part 9 of the Federal Constitution, which incorporates several safeguards to enhance judicial integrity and judicial independence. Such safeguards are constitutionally provided to stop interference from the executive or legislature. Judicial independence is often misunderstood as something that is for the benefit of the judge It is not. It is the public's guarantee that a judge will be impartial. Judicial independence protects individuals and the community. The protection of judicial independence is enforced so that the public know that they were dealt with fairly, that they receive any improper outside influence, and by a judge who was bound only by his or her oath to office, which is to render justice according to law. To efficiently meet its objective, judicial independence must also protect judges. The role, to a great extent, is played by judges themselves, and it is a role played not out of self-interest, but as an obligation to the public, which has entrusted them with the decision-making power and to whom they are ultimately accountable to. Of course, the judiciary have a self-help procedure, which is contempt of court. Another aspect of judicial independence is judicial immunity. In the performance of the judicial functions, all judges are immune from the law of torts and crime by a number of provisions of law. At present, the prevailing obstacle to achieve improved judicial independence hinges upon the necessary and seriously looked into by the government of the day. The first amendment would be to Section 27 of the Judicial Appointments Act 2009, which provides the Prime Minister with the privilege of requesting for additional names for consideration with respect to vacancies in the top four, the Federal Court and the Court of Appeal. Amendments to Article 122B of the Federal Constitution to remove the privilege of the Prime Minister in advising the Yang di-Pertua Agong on the appointment of the judges of the Federal Court, Court of Appeal, and the High Court. 3. Amendments to Section 5, Sub 1, Sub 4, Sub F, of the Judicial Appointments Commission Act 2009, which provides the Prime Minister with the privilege of appointing 4 eminent persons to the Judicial Appointment Commission, comprising of 9 members. And 4, made available to the public for free, definitely fulfills this requirement. Citizens can only get justice if they are able to find out relatively easily what their rights are and what are their duties. If there is any scope of improvement, it would be for the Attorney General's chambers to publish all relevant laws applicable in Malaysia upon its website and make such laws available and easily accessible to all. In regards to access to courts, generally the courts in Sarawak is operating in an efficient manner, wherein cases do proceed as scheduled and timeously. Although there were some disruptions caused by the lockdown owing to the COVID-19 pandemic, the courts have taken steps to ensure that cases are not left idling in court. Such steps, which includes proceeding with cases using remote communication platforms or technology. This initiative has since been codified through the recent amendments. The association also wishes to highlight that even during the peak of the COVID-19 pandemic, at a time of crippling lockdowns, the Sarawak judiciary was still actively hearing cases involving offences under the Movement Control Order. One example of this was the commendable actions of Yang Arif Din Wendeli, who fully made himself available to travel. The physical aspect of access to courts requires that the courthouses in Sarawak be adequately maintained and adequately equipped to accommodate all layers of the society. All layers which include the disabled or the elderly. We note that at present, the only courthouse in Sarawak installed with a lift facility is right here in MIRI. There is an obvious need for this situation to be improved to create a more conducive environment for the elderly and disabled in the courthouses in Sarawak. Another issue I'm constrained to highlight, my lady and my lords, is that it is imperative for the courts to efficiently and timely maintain the court facilities. This will assist to circumvent any breakdown of facilities. An example of this is the prevailing situation faced by the users, which include the 100 overstaff working at the MAHKAMAH Kuching, where the air conditioning system of the courthouse there have been broken down since July 2022. The Pengarah MAHKAMAH Sarawak, Tuan Steve Ritikos, have been working tirelessly with the association's Kuching branch to find ways to mitigate this, and the contractor have since been appointed to change the faulty chiller system within the courthouse. Conditions remain unbearable as there is very poor ventilation. I sincerely hope that more urgent actions can be taken to alleviate this issue, and I do hope that Yang Berhormat Tuan Ram Karpal Singh, anak lelaki Karpal Singh, the Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, who is in attendance today, would take heed of the issues faced by us. The association also welcomes the government's decision, relayed by the then Minister in the Prime Minister's Department, Parliament and Law, that 4 new courthouses have been proposed to be built in Limbang, Seriaman, Mukah and Kapit. This is definitely a step in the right direction to grant access to justice to the citizens living outside the big towns and cities in Sarawak. Of access to legal representation, I am pleased to record that the practice of advocates is spread throughout the large islands that make up Sarawak. From the north in Lawas to the south in Kuching, members of public would not face difficulty in finding suitable lawyers to provide them legal representation. I am pleased also to update that the association, through its members, have been playing an active role in fulfilling its social responsibility in providing access to legal representation to all parts of the society. I note as follows. YBGK. The AS have been actively conducting YBGK trainings sessions to equip advocates with the necessary skills required. 5.5 million, and this sum is supposed to be shared among all lawyers in Malaysia. What is clear is that despite the attempts made by advocates to attend to YBGK cases and to ensure that all levels of the society has legal representation, the government has indirectly created a hurdle by underfunding YBGK. Assigned counsel. I am pleased to note that all members have taken up all requests for assigned counsel, and there are no accused persons unrepresented for trials in the High Court. CSR. The AAS has always believed in contributing to society. With this in mind, the association has in the past carried out various outreach programs together with the Sarawak Judiciary. However, due to various movement control orders imposed by the government, this has not been possible. The AAS is committed, together with various stakeholders, in continuing with these outreach programs now that we are in the endemic stages. The byproduct of such programs is the opportunity created for the interior folks to have access to justice through obtaining legal representation and advice. The AAS shall continue its efforts on this front and have scheduled more programs in the near future. We look forward to having my lady and my lords to join us during such programs. My lady and my lords, for an issue which requires attention, association raises with much concern the lack of access to justice for children, especially children in rural areas. We urge the relevant stakeholders to carry out amendments to the Sexual Offences to Children Act to ensure that children are not criminalized in the zeal of the public prosecutor carrying out their duties. Further, there is only one special court dealing with sexual offences against children, which is located in Kuching. To ensure that there is access to justice for all children, especially children who live in the interior, it is only fit that existing courts in all districts must be equipped with video link facilities to ensure the protection of vulnerable witnesses, especially children. It is also crucial for all stakeholders dealing with children, especially DPPs, judges, interpreters, to be given specialized trainings. It is time to create specialists in this area. My lady and my lords, proposed amendments to the Federal Constitution. During the opening of the legal year 2023 ceremony held in Putrajaya International Convention Centre, the Attorney General, during his address to the bench, announced that there are plans to propose for the Bahasa Malaysia translation of the Federal Constitution to be made formal via Article 160B of the Federal Constitution. The Advocates Association of Sarawak views such plan with much concern, as the association was never consulted over such intentions. Nonetheless, the association associates itself with the position that such proposals should not be made. The current format of the Federal Constitution have been tried and tested in the courts of law, where there are landmark cases decided mainly upon interpretation of singular words. English is widely used in Commonwealth countries. Therefore, one is able to draw upon decided cases of other Commonwealth countries as legal precedent to assist to determine any ambiguity over the Federal Constitution in its current format. However, due to lack of jurisprudence in the national language, as Malaysia is the only country using Bahasa Malaysia, one would not have the same privileges. Another significant point is that a number of other agreements, like the Federation of Malaysia Independence Act 1957 and of particular interest to Sarawak, the Malaysia Agreement 1963, are all written in English. There is a foreseeable situation that the courts in Malaysia will be flooded with considerable constitutional crises over such plans. The association notes that in a recent press release, Yang Amat Berhormat Premier had taken the position that the state government shall continue to use English as its official language alongside with the national language. We take solace upon the position that the Federal Constitution cannot be amended in such a manner as proposed by the Attorney General in view of Article 161 sub 3 of the Federal Constitution, which requires consent of Sabah and Sarawak. My Lady and my Lords, at the same opening of the legal year 2023, the President of the Bar Council, Ms. Karen Chia Yi Lin, during her address to the bench, highlighted a number of issues and proposed amendments to the laws which require urgent attention. The Advocates Association of Sarawak associates itself with the proposals made by the President of the Bar Council. My Lady and my Lords, conclusion. To our members, it is right and proper for legal practitioners to make the strongest case possible and to do their utmost for their clients, always within the confines of the law. We must always remember that we owe our first duty to the courts. To the courts, I reaffirm the association's pledge of our members to do their duty, to assist the courts with diligence and integrity, and for the enhancement of legal practice and services in Sarawak. On behalf of the Advocates Association of Sarawak, and all present here today, a warm wishes and prayers for good health, continuing wisdom, strength, fortitude for the year ahead. I am very much obliged, my Lady and my Lords. No clapping.
I now invite Mr. Roger Chin
Justice of Malaysia and member of the Judicial Appointments Commission, the Right Honourable Tan Sri Dato' Amar Abang Iskandar bin Abang Hashim, Chief Judge of Sabah and Sarawak, the Honourable Dato' Muhammad Zabidin bin Muhammad Dia, the Acting Chief Judge of Malaya, and Yang Berbahagia Datin Sharifah bin Dato' Dr. Chair Rus Elias Darus, Yang Berhormat Tuan Ram Kapal Singh, anak lelaki Kapal Singh, the Deputy Minister at the Prime Minister's Department, Law and Institutional Reforms, the Honourable Judges of the Federal Court, the Honourable Judges of the Court of Appeal, the Honourable Dato' Ahmad Teriruddin, Chief Registrar of the Federal Court of Malaysia, the Honourable Mr. Gurveer Singh Sandhu, President of Advocates Association of Sarawak, the Honourable Mr. Muhammad Ezri bin Abdul Wahab, Vice President of the Malaysian Bar Council, the Honourable Pangeran Izzat Ryan bin Pangeran Haji Bahrain, representative from the Law Society of Brunei Darussalam, Yang Berhormat Tuan Adam Yee Siu Sang, Mayor, MIRI City Council, heads and representatives of the federal and state departments and agencies, judicial and legal officers, members of the bar, distinguished guests, ladies and gentlemen. It is a privilege to be here at today's opening of the legal year. As a new legal year begins, my mind turns to the enduring success of our legal system over the decades, with judicial independence and the rule of law at its heart. Indeed, judges take an oath to discharge their duty to the best of their ability, that in their respective constitutional limits. In many ways, a judge's role is right at the front line, where the law meets policy and policy meets law. There will be tensions at times, which can be difficult to resolve. Those observing who aren't privy to all the issues are naturally and understandably tempted to come to hard and fast conclusions. Sometimes the lawyer will find that the argument they advance can and should occur. Malaysian Judicial Renaissance. In 2022, the Malaysian judiciary continued out that the 1988 amendments to Article 121 of the Federal Constitution to remove judicial power from judges did not have the desired effect. Instead, these two judgments of the Federal Court had effectively held that such powers had always remained vested in the Superior Court since Merdeka Day, in spite of the amendments to the article. This is known as the basic structure doctrine, which essentially holds that the federal constitution's basic structure, including judicial powers, such as judicial review, the principles of separation of powers, rule of law, protection of minorities. Parliament cannot remove such features by amending the Constitution. The Federal Constitution's Article 121, bracket 1, vests even when the matter is related to Islamic law. There, the Hindu mother succeeded in obtaining a federal court ruling that quashed her ex-husband's unilateral conversion of their 3 children to Islam without her knowledge or consent. The case cleared up the confusion by declaring that unilateral conversions of children to Islam are unlawful. In this resurgence, the Malaysian judiciary can finally release itself from the shackles of the 1988 amendments to Article 121 and be paralyzed with indecision no more, including where matters involve Islamic law. Notwithstanding the federal court's decision, the icing on the cake would surely be the repealing of the 1988 amendments to Article 121 in the federal constitution by the Malaysian government to affirm and announce to the world that judicial power remains with the judiciary in Malaysia. Tun Tengku Maimun continues to nurture and harness this judicial revitalization, and nowhere more evident of this revitalization was the manner in which she presided over the final appeal of ex-Prime Minister Datuk Sri Najib Tun Razak at the federal court. The Malaysian judiciary has rediscovered its voice and had another coming of age. Tun Tengku Maimun decisively and firmly handled and decided on several legal moves by Najib's team of lawyers, culminating in the 5-member bench led by her affirming Datuk Sri Najib's 12-year jail sentence for misappropriating millions of dollars from a company linked to State Fund 1 Malaysia Development Berhad, otherwise known as 1MDB, thus becoming the country's first ex-Prime Minister to be jailed. In a speech which Tun Tengku Maimun made in 2021 at the Australian-Indonesia Partnership for Justice webinar, she said the task of a judge was onerous, and it was reflected in the oath that judges took, namely, to bear true faith and allegiance to Malaysia and to preserve, protect, and defend the Constitution. She added that the Malaysian community hoped that she would restore the judiciary to its past glory and that she would put in place righteous judges to adjudicate cases at hand. All this she has done, and their effect will strengthen the rule of law in Malaysia to no end. Judicial interference. The nation was awash by news and reports recently expressing calls by political figures for interference of the Prime Minister in the judicial process. Some have even gone as far as demanding for direct interference to the federal court concerning the case of former Prime Minister Datuk Sri Najib Razak, and for a change of the current Attorney General and/or personnel within the Office of the Chief Justice of Malaysia. It is deeply disturbing that such calls to interfere in the judicial process or to replace the current Attorney General and/or personnel within the Office of the Chief Justice of Malaysia are made in blatant disregard of the principle of separation of powers and the entrenched constitutional democracy of Malaysia. Malaysia is a country that values the separation of powers between the executive, legislative, and judicial branches, as this provides checks and balances against one another. The primary duty of the Attorney General is to uphold the integrity of the justice system within his powers under the Constitution, and the primary duty of the judiciary is to interpret and give effect to the law. At the heart of the judiciary is the independence of judges to exercise their powers without any intrusion from individuals, entities, or political parties. It is a judiciary that bears the responsibility of resolving disputes fairly in accordance with prevailing laws, not heeding to the requests of politicians or anyone else. It bears reminding that the fundamental concepts of judicial independence and separation of powers between the 3 pillars of governance, the legislative, executive, and judiciary, are basic hallmarks of any functioning democracy. These principles are integral to maintaining the rule of law. Political interference in any case, especially one of tremendous public interest, directly encroaches upon the functions and duties of the Attorney General and the court. The constitutionality of such alleged integrity of the Attorney General and the judiciary. SLS condemns any act of politicians seeking for an intervention by the politicians have been admonished. Some even charged for such actions to interfere, as these actions are considered abuse of power and a misfeasance of public duties. The acts of politicians in recent history openly discussing calls for interfering with the judiciary in legal actions erodes faith in the judiciary and are deeply damaging to the rule of law in Malaysia. This sort of behavior is tantamount to an attack on the independence of the judiciary. Politicians should not be making scurrilous remarks which only serve to perpetuate misgivings and suspicion amongst the people towards our judiciary. The time has come for politicians to understand their roles in perpetuating and strengthening the rule of law, including the doctrine of separation of powers, instead of turning Malaysia into a legal pariah where rule of law is not sacrosanct and whenever they utter unjustifiable statements. We must never forget that it is the courts that we turn to for justice, and it is the last bastion of hope and final line of legal recourse available. The courts are beholden to no one but the law, and it is the duties of judges to dispense justice in a manner that is in accordance with the law and not to individual or political parties. In the face of relentless attacks on the judiciary, SLS took the unprecedented step and with over 100 Sabah lawyers peacefully assembled and participated in the walk for justice from the Damai Community Hall to the Kota Kinabalu Courthouse on 17th of June 2022 in solidarity with the planned peaceful march to Parliament by our brothers and sisters in the law in Peninsular Malaysia to support, defend, and uphold, shoulder to shoulder, the justice system. This was a first for SLS and marked as well the first time a non-political assembly was held in Sabah, proving that an assembly can be peacefully held, and SLS extends its gratitude to the police and relevant authorities for their cooperation. SLS, as a stakeholder in the justice system, is obliged to work together with all interested parties to strengthen judicial independence and will not hesitate to stand by and defend our institutions against unwarranted criticism. Justice can never be cowed, and the rule of law will always prevail. Malaysia Agreement 1963 and the Malaysia Act 1963 and the advances made. It is heartening to note that of late, the commitment to fulfill MA63, the bedrock or foundation of Malaysia, by Malaya, Singapore, Sabah, and Sarawak, has gathered pace, resulting in recent announcements of plans for Sabah State to regulate its own electricity and gas supply. Beginning with electricity supply on 3rd of October 2022, the Renewable Amendment Bill 2022 and the Sustainable Energy Development Authority Amendment Bill 2022 were passed by the Dewan Rakyat. Amendments to the Renewable Energy Act 2011 and the Sustainable Energy Development Authority Act 2011 inserts a new subsection in the two acts, giving the federal minister the power to suspend any provisions in the two acts in different parts of Malaysia. For gas supply in Sabah, the federal government has announced its decision to transfer the regulatory power over gas supply to Sabah, with the date for the transfer to be made after getting consent of the Yang di-Pertuan Agong. Upon the King's consent, the Sabah State Assembly will convene a special sitting to approve and gazette the Sabah State bills for gas supply, and SEC will take over all regulatory powers for onshore gas supply in Sabah with immediate effect. As laudatory as the state government's pursuit to take control and manage the state's oil and gas resources and take steps forward in realizing MA63 are, it should be noted that the federal government had unilaterally revoked the delegation of power to pass laws in the federal list in 1984. The delegation was made in 1962 after the intergovernmental committee meeting and before the signing of MA63. Since the unilateral revocation, electricity and gas supply remains with federal government until today, in breach of MA63. In fact, the federal government in 2016 to 2017 had agreed to rectify this and restore the delegation to regulate in 1962. The present push for devolution would not have been necessary if only state rights were vigilantly guarded jealously in the past, including taking necessary court actions where needed, and especially when such state rights were dealt with slipshod. Power, once obtained, is never relinquished easily, and this obviously has been the case here for some 50 years. This brings us naturally to issues in relation to various laws, such as the Continental Shelf Act, the Petroleum Mining Act, the Petroleum Development Act, the Exclusive Economic Zone Act, and the Territorial Seas Act, otherwise known as TSA. The TSA is a law that was passed by Parliament in 2012. Essentially, it outlines the limits of the area of sovereignty of the country and its states from the coastline. This includes the sea, the seabed, and the subsoil, which is a layer of soil underneath the seabed. In 2011, then Prime Minister Datuk Seri Najib repealed the emergency proclamations declared by previous Yang di-Pertuan Agongs, which made the Continental Sea Act, the Petroleum Mining Act, the Petroleum Development Act, or PDA, and the Exclusive Zone Act applicable to the Bornean states, whilst the proclamation of emergency was still in force. Under the Emergency Essential Powers Ordinance No. 7 of 1969, which came into force on August 10, 1969, the territorial waters of all states were limited to 3 nautical miles. Before 1963, the whole continental shelf belonged to Sabah and Sarawak and had sovereignty over waters up to 12 nautical miles from their shores. The repeal of the emergency proclamation meant that the territorial waters of states, notably the oil-producing states of Sabah, Sarawak, Kelantan, and Terengganu, were no longer capped at 3 nautical miles, or they should have. However, the TSA was then passed, ostensibly to bring Malaysia in line with the law of the Sea Convention 1982, a multilateral treaty governing oceans. Prior to Malaysia Day, the Borneo states exercised powers over petroleum found within its extended boundaries, that is, the seabed and subsoil, which lie beneath the high seas contiguous to the territorial waters of the respective states. With their boundaries maintained by virtue of Article 1(3) of the Federal Constitution, after the Malaysia Day, the 2 states continued to exercise right over petroleum found within its territories, including those offshore. According to Article 1(3) and 2 of the Federal Constitution, the territories of such states mentioned in Clause 2 are the territories comprised therein immediately before Malaysia Day, and that a law altering the boundaries of a state shall not be passed without consent of the state, expressed by a law made by the legislature of the state and of the Conference of Ruler. This was never done. The constitutionality of the TSA is consequently questionable. The enforcement of TSA means that Sabah is potentially denied additional revenue from resources beyond 3 nautical miles. The economic implications are obvious, and Sabah cannot monetize her own resources. Whilst SLS is aware that the commercial collaboration agreement between the state and Petronas seeks to provide a more equitable share and participation of the valuable oil and gas resources of Sabah, the constitutional and legal rights of Sabah state remains. Adequate electricity and gas are the lifeblood of development and manufacturing. Without the ability to control and regulate these autonomously, Sabah will always find it difficult to attract investments, especially foreign direct investments, into the state, and resolution by determining the constitutionality of the TSA could result in Sabah being able to license or permit and therefore regulate offshore oil and gas activities above and beyond just devolution of powers. Additionally, whilst the PDA and the ensuing agreement between the states and Petronas and the state and Petronas to provide 5% cash payment to the state in return for the ownership of right over petroleum, whether offshore or onshore, have long been the subject of cynical scrutiny by Sabahans, including the constitutionality of the same. And moving forward, in conjunction with the resolution of issues regarding the TSA, it would be necessary to ensure that the oil and gas resources of Sabah are shared in a fair and transparent manner for the benefit of the state, which is unfortunately resource-rich, but still one of the poorest in Malaysia, as stated in the World Bank Report 2022. Ultimately, ownership of resources by the state and not merely given regulatory powers should be the aim. All in all, the advances made good progress towards redemption of rights that were repealed or had not been enforced in letter or spirit under MA 63. However, more needs to be done, and amongst these are: 1. Appointment of judicial commissioners and sufficient representation of Borneo judges in the appellate courts. 2. Elevation of the native courts of Sabah to be on par with Sharia courts. And thirdly, recognition of advocates who had been admitted to the High Court in Sabah and Sarawak, joining the Judicial and Legal Services Commission, where such advocates have been admitted to the Commonwealth Supreme Court or High Court pursuant to Section 4 of the Advocates Ordinance. Appointment of judicial commissioners and the need to maintain sufficient Sabah and Sarawak representation in appellate courts. SLS fully supports the call by Yang di-Pertuan Besar of Negeri Sembilan, Tuanku Muhriz Ibni Al-Mahrum Tuanku Munawir, in his opening speech at the second day of the 260th Conference of Rulers at Istana Negara, for the appointment of the 4 members of Judicial Appointment Commission to be made by SLS, Advocates Association of Sarawak, Bar Council, and the Parliament Committee of Selection instead of by the Prime Minister. However, SLS reiterates its call for the return of the eroded authority and rights of the state of Sabah and Sarawak by restoring the power of the respective governors to appoint judicial commissioners provided for in the Federal Constitution prior to 1994. The amendments to Article 122 included the introduction of new articles, including Article 122AB of the Federal Constitution, which takes away the power of the respective governors of both Sabah and Sarawak to appoint judicial commissioners. The new Article 122AB is about the appointment of judicial commissioners for the dispatch of business in the High Court of Malaya, High Court of in Sabah and in Sabah by Agong on the advice of the Prime Minister after consultation with the Chief Justice of the Federal Court. There is no requirement to consult Sabah and Sarawak in the new Article 122AB. However, the amendment to Article 122 of the Federal Constitution, particularly the new Article 122AB, should only have been made after federal government obtained the concurrence of the governors of Sabah and Sarawak. Article 122AB of the Constitution was passed without consent of the respective state government and thus contravened Article 161E, bracket 2, bracket B of the Federal Constitution. Article 161E, bracket 2 provides that no amendment is to be made to the Federal Constitution without the concurrence of the Yang di-Pertuan Negeri of Sabah and Sarawak, where such amendments affect the Constitution and jurisdiction of the High Court in Sabah and Sarawak and the appointment, removal, suspension of judges in the courts of Sabah and Sarawak should also be fixed. To fill these positions, separate pools consisting of only judges from Sabah and Sarawak each should be chosen from to determine suitability to fill in any vacancies there. If Sabah and Sarawak judges were to be lumped together with Peninsular Malaysia judges, and one of the criteria for promotion is seniority, one can see how the sheer number of the latter would mean that there would nearly always be more senior judges from Peninsular Malaysia to be elevated, leaving the number of Sabah and Sarawak judges at the appellate courts at a minimum. This affirmative action would also go a long way to facilitate Bornean representation in hearing cases filed in Borneo. Judges with Bornean judicial experience are essential in ensuring justice is delivered without fear or favor in cases involving unique Bornean local conditions and customs. Elevation of the native courts of Sabah to be on par with Sharia courts. Under the Federal Constitution, native customary law and the native courts are state matters regulated by state legislation as provided for under the Federal Constitution for the states of Sabah and Sarawak. Assistance is required from all relevant stakeholders to uplift the native courts in Sabah to be on par with the Sharia courts, which would go a very long way to restoring the spirit of MA 63. native courts and Sharia courts are of the same status constitutionally, and neither is subservient to the other, and accordingly, the native court's jurisdiction cannot be made to exclude any cause or matter within the jurisdiction of the Sharia courts. Any state laws purporting to do so could prove unconstitutional. In this respect, SLS would like to thank the Yayasan Bantuan Penguaman Kebangsaan, YBGK, in principle, agreeing to cover the provision of free legal representation to Native Court of Appeal parties in cases of breach of native customary law under the Native Court's Native Customary Laws Rules, 1995, beginning in 2023. Recognition of advocates who have been admitted to the High Court in Sabah and Sarawak joining the Judicial and Legal Services Commission, where such advocates have been admitted to the Commonwealth Supreme Court or High Court. The Advocates Ordinance recognizes multiple routes of eligibility to be admitted as an advocate in Sabah. 1, having graduated from a Malaysian public university. 2, having undertaken and passed the certificate in legal practice. 3, being a member of the Bar of England. Or 4, by virtue of having been admitted to practice as a legal practitioner by a Supreme Court or High Court within the Commonwealth Territory. There are a number of graduates from the Australian or New Zealand universities who have subsequently undertaken the requisite postgraduate course to enable them to be admitted to the bar of either Australia or New Zealand, who thereby satisfy the criteria as stated in the Advocates Ordinance to be admitted as an advocate in Sabah. Such advocates have been admitted to a Commonwealth bar, such as Australia or New Zealand, therefore do not need to sit for the certificate in legal practice to be admitted as an advocate in Sabah. The criteria for an application to positions in the Judicial and Legal Services Commission, however, do not recognize the eligibility for such advocates who have been admitted to a Commonwealth bar, such as Australia or New Zealand, as it is specified that such positions are only available or are only available for those who are in possession of a degree from a Malaysian public university or have a certificate in legal practice. Presumably, the aforesaid prerequisites are required in order to be consistent with the definition of a qualified person pursuant to the Legal Profession Act. Unfortunately, this may deny suitable advocates from both Sabah and Sarawak who do not have the certificate in legal practice from applying to join the Judicial and Legal Services Commission. Furthermore, the criteria to be appointed to the Superior Courts in Malaysia do not require such candidates to be in possession of a Malaysian public university degree or a certificate in legal practice, but need only be recognized as advocates of High Court in Sabah and Sarawak. SLS hopes that this anomaly can be reconciled so as to enable advocates from both Sabah and Sarawak to be eligible to join the Judicial and Legal Services Commission, notwithstanding that they do not possess the certificate in legal practice. Public interest litigation. We live in extraordinary times where the Constitution is now more than ever requiring the courts to step in to interpret. SLS takes the firm stand that all parties are entitled to challenge the constitutionality of laws enacted in Malaysia, whether they be state or federal laws. This is a hallmark of a democracy, and the people should not be deterred to seek recourse with the courts. The provisions of the federal constitution must be upheld at all times, although there may be concerns as to perceptions which should be managed with tact and diplomacy. Ultimately, the rule of law and provisions of the federal constitution must always be preserved and upheld. SLS encourages public interest litigation and challenges to the constitutionality of any laws passed, whether state or federal, throughout the country. It is only through challenge that laws can be truly described as tried and tested. If laws are validly passed, no party should fear a challenge to the constitutionality of the same, and nobody should be seen to discourage such challenges. In 2022, SLS commenced an action against the federal government by way of judicial review, proceeding from a certiorari to quash the second review order insofar as it contravenes the specific provisions of the Federal Constitution, more particularly Article 112C and 112D, read together with the 10th Schedule, Part 4 thereof. SLS is of the view that under Article 112D(3), it is incumbent upon the federal government to hold a second review in 1974. The federal government failed or neglected to hold that second review in clear contravention of the express provisions of the Federal Constitution. This contravention is to the detriment of the people in the state of Sabah. The second review, now published in the recent Federal Gazette on 20th April 2022, is only in respect of the years 2022 to 2026. It is felt to address the lost years from 1974 to 2021. By failing to uphold that review from periods from 1974 to 2021, the people of Sabah have lost the benefit of the 40% entitlement as of right under the Federal Constitution. This right and entitlement is sacrosanct, as enshrined in the Constitution, foundation documents, and indeed the Constitution itself. SLS's action is for the preservation of the constitutional rights of the people of Sabah. Like clockwork, the Attorney General Chambers defended the action and amongst others, raised the issue of SLS's lack of locus standi, submitting a regressive and restrictive version of locus standi in the court. Public interest litigation is a branch of administrative law which involves judicial review of administrative action and has a pivotal role to play in an administrative state, particularly in the promotion of good governance. Initiated by citizens and interested parties who may not be directly affected by administrative actions, such public interest litigants are often frowned upon by the executive. The evolution of public interest litigation in paragraph 1, schedule for the Courts of Judicature Act, which provides for remedies for enforcement of fundamental rights, is affected by the differences of judicial attitude in giving interpretation on the issue of standing under Order 53, Rule 2(4) of the Rules of Court 2012. On one hand, some judges take a strict and narrow approach on the interpretation of the issue of standing. On the other hand, some judges take a more and less rigid approach towards interpretation of the issue of standing. This scenario has uncertainty for public interest litigation in paragraph 1. Public interest litigation plays a critical role to maintain the rule of law and enhance access to justice for disadvantaged groups under public law. Consequently, the court should relax further the rules on locus standi in public law to permit any public or interested party acting bona fide with a view to vindicating the cause of justice to make application on behalf of others or a particular class of people if that other person or class of action cannot come to a court to get relief for some reason. It is a grave lacuna in the system of public law if public interest litigation is prevented by limited rules of locus standi. The Attorney General of Malaysia is the principal and main legal advisor to the government of Malaysia. He or she is also the protector of the public interest. The irony is there is a conflict between the role of an Attorney General as the protector of public interest and his loyalty to the legislative and executive agency of the state. The question that begs to be asked is, what happens when the Attorney General, for whatever reason, does not protect the public interest or even raises it? What happens when parties directly affected do not initiate actions for reasons best known to them? Surely, a very liberal locus standi law on locus standi in Malaysia would go a long way to rectify this and permit access to justice, particularly when real livelihoods are often affected directly or indirectly. Borneo International Center for Arbitration and Mediation. Lastly, as foreshadowed in the opening of the legal year in 2020 at Kuching, SLS is proud to announce that the Borneo International Center for Arbitration and Mediation, otherwise known as BICAM, now is in the midst of renovations, will finally be opened and launched in the first few months of this year. BICAM is an independent international arbitration and mediation center set up with the objective of providing quality and cost-efficient arbitration and mediation services for users in Malaysia and around the world, especially the region, including Nusantara and Bimpiaga. BICAM is presently funded by the Sabah state government with foresight to enhance foreign direct investment by providing a center to resolve international commercial disputes. This will be the very first dispute resolution center set up with the backing and funding by a state and shows Sabah's resoluteness in encouraging and welcoming FDI. Examples of such successful centers are Singapore International Arbitration Center and the Hong Kong International Arbitration Center, and the role they play in attracting FDI is well known. As a founding member of BICAM, SLS would like to invite Sarawak State Government and the Advocates Association of Sarawak to support and be part of the center so as to be a truly East Malaysian dispute resolution center of our own. And we envisage a center also being established in Sarawak, whereby arbitrations in Sarawak would be done there, and the Sarawak Arbitration, Mediations, Councils, and Arbitrators Mediators can then keep income generated from such proceedings within Sarawak. This is more important in the light of the federal court's decision in Masenang versus Sabah Nilam enterprise, where the federal court held that the courts of first instance of the place specified as the seat of arbitration in Malaysia has exclusive supervisory jurisdiction over arbitration seated in that place, including any award arising from such proceedings. It is not difficult to imagine a scenario where the two parties entered into a construction agreement in Sabah and the project site is in Sabah, but the place of arbitration, and therefore normally the seat of arbitration, stated in the agreement is in Kuala Lumpur, and because of this, have to do the arbitration in Kuala Lumpur, and after the arbitration, engage lawyers in Peninsular Malaysia to enforce or set aside the award there. BICAM will continue the good work of SLS in providing the mediation services under the Pusat Mediasi COVID-19, wherein Sabah undertook the greatest number of mediations by far as compared to any other state or territory in Malaysia combined, and all with a 100% success rate. BICAM intends to engage with the courts on how BICAM can assist, for example, providing the court mediation services, and where appropriate, BICAM can provide arbitration services to litigants in lieu of going through the full judicial process to free up courts' time so that they can focus on judging. In conclusion, allow me to recite a short pantun. Di awal persekutuan indahnya percakapan, janji manis sentiasa diberi. Apa digendong telah banyak dilepaskan, akhirnya mengemis di kemudian hari. Tara, solusi kekal itu yang kami diambakan. Jangan lekah di dalam rimba jika tidak mahu ditekam pak belang. Hak negeri Borneo sentiasa kami jagapan lalu tidak berulang. Thank you for listening, and I wish everyone here the very best wishes for the legal year ahead. Happy New Year, good health, and good fortune.
Of the State Attorney General of Sarawak.
The Right Honorable Tun Tengku Maimun binti Tunku Tuan Mat, the Chief Justice of Malaysia, and Yang Amat Berbahagia Dato' Zamani bin Ibrahim. The Right Honorable Tan Sri Dato' Amal Abang Iskandar bin Abang Hashim, Chief Judge Sabah Sarawak and Acting President of the Court of Appeal. The Honorable Tun Muhammad Raus Sharif, former Chief Justice of Malaysia, and covering duties of the Chief Judge of Malaya. The Honorable Yang Berhormat Tuan Ran Kapal Singh, Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms. Honorable members of the Judicial Appointments Commission, Honorable Commissioners. Is it? The Honorable Dato' Ahmad Tari Rudin, Solicitor General 1 of Malaysia. The Honorable Dato' Noor Ashah Muhammad Yusof, State Attorney General of Sabah. Presidents of the... First and foremost, I would like to extend the Sarawak State Attorney General's Young Arif Dato Sri Talat Mahmud Abdul Rashid's apologies for not being able to attend the opening of this legal year due to prior commitments. My lady, my lords, with your leave, I will now proceed to read out the Sarawak State Attorney General's speech. It is an honor for us from the State Attorney General's chambers to attend this time-honored tradition to reflect on the progress and contributions we have made as participants in the legal system of the country. In this respect, I am happy to share a few of our chamber's accomplishments for the year 2022, particularly regarding new legislations drafted by our chambers. During the year 2022, a total of 11 bills were tabled and duly passed by the Dewan Undangan Negeri. All these bills were the result of a lot of hard work and research, as well as input from all relevant stakeholders. I would now like to highlight those bills which we found have attracted the most public interest. Native status and the issue of mixed blood. In December 2021, Parliament passed the Federal Constitution Amendment Act, Amendment Bill 2021, which inter alia amended Article 161A, Clauses 6 and 7 of the Federal Constitution. The effect of the amendment is to confer on Sarawak the legislative power to determine races indigenous to Sarawak. This is rightly so, as the determination of native status is a state matter. Subsequently, on 15 February 2022, the Dewan Undangan Negeri passed amendments to the Interpretation Ordinance 2005, substituting the schedule thereof with a new schedule listing 31 races indigenous to Sarawak. The previous schedule only listed 20 racial groups. The amendment also appears to resolve the thorny issue of children born to parents, one of whom is a non-native. Prior to the amendment, if one parent is a non-native, the children of that marriage based on historical reality. The Federal Constitution Amendment Act 2021 also amended Article 160, Clause 2, providing for a new interpretation of federation, which now also makes reference to the Malaysia Agreement 1963. In line with this new interpretation, the interpretation of federation in Article 44 of the Sarawak Constitution was also amended to be consistent with and to reflect the new interpretation in Article 160, Clause 2 of the Federal Constitution. In this regard, we would like to record our gratitude and appreciation to the Federal Attorney General and his officers for the efforts which made these amendments possible. Digitalization for a new economy. It has always been the government of Sarawak's top priority to give its best service to the people of Sarawak. This is in line with the aspiration of the Premier of Sarawak that Sarawak becomes a modern and leading digital economy and society by the year 2030. As one of the means to fulfill this aspiration, the Electronic Sarawak Government Activities Bill was passed by the State Legislative Assembly during its sitting in November last year. The Electronic Sarawak Government Activities Ordinance provides the necessary legal framework for the Sarawak government, local authorities, and statutory bodies to become e-enabled without the need for further amendments to other state laws. The enactment of this ordinance will realize the vision of the government of Sarawak for the state to embrace digitalization as a tool to accelerate its service delivery to the people of Sarawak and empower Sarawak's economic sectors to increase their efficiency and productivity. Climate change and carbon trading. Climate change has become a global concern over the last few decades. We have already seen a crescendo of deadly and costly extreme weather, from heat waves and drought to flooding and tropical storms, made more destructive by rising seas. During COP27 UN Climate Summit in Egypt, held at the end of last year, it was acknowledged that carbon emission reduction is key towards fighting climate change. In this regard, I am happy to share with you that the government of Sarawak is serious and committed to playing a role in combating climate change and promoting environmental sustainability. A clear indication of this commitment was the enactment of the Forest Amendment Ordinance and the Land Court Amendment Ordinance. These amendments empowers the Sarawak government to regulate forest carbon activities as well as to regulate the usage of land for the purpose of carbon dioxide or other greenhouse gas storage. The procedures and requirements needed to apply for forest carbon license and carbon storage license are provided in subsidiary legislation, namely the land storage, carbon storage rules, and the forest carbon activity rules, both of which have recently been approved by the State Cabinet. I am proud to inform that Sarawak is the first state in Malaysia to enact legislation permitting nature-based solutions in the form of forest carbon activities and carbon projects. Through this legal framework, the government of Sarawak will also be able to have an additional source of income through the generation of carbon credits and the imposition of taxation by way of royalties and license fees. And at the same time, Malaysia will be able to fulfill its obligations under the Paris Agreement. Anti-hopping law. The Sarawak Constitution previously already had provisions on anti-hopping. However, with the new anti-hopping measures passed recently by Parliament, it was necessary for the government of Sarawak to also amend its constitution through the introduction of a new Article 16B to incorporate the same provisions on anti-hopping in line with the requirements of Article 71 and the S Schedule of the Federal Constitution. This, it is hoped, should prevent any member of a political party who has been elected as a member of the State Legislative Assembly on that platform from jumping ship. It is to ensure political stability in the state. Building sustainable wealth for future generations. I am pleased to report that the Dewan Undangan Negeri had on the 22nd of November 2022 passed the Sarawak Sovereign Wealth Future Fund Board Bill to establish a body corporate to be the custodian of a state fund, to be known as the Sarawak Sovereign Wealth Future Fund, for the purpose of converting the state's non-renewable assets to financial assets by investing and safeguarding monies in the fund and for the sustainable growth thereof in the interests of Sarawak and the future generations of its people. In this way, the wealth of the state is secured for the benefit of our future generations. This ordinance is benchmarked on best international practices to promote and ensure proper governance and internationally accepted level of integrity and transparency when dealing with public funds. In addition, the guardians of the board will be appointed based on merits and appreciation and experience, and no politically connected persons will be involved. With more and more responsibilities coming our way, in particular the drafting of new legislations and the prosecution of offences under state laws, our chambers has begun to strengthen its resources, particularly its human capital. I wish to take this opportunity to thank the Federal Attorney General for giving us the trust and power to handle prosecution of offences under our own state laws. I wish to assure the people of Sarawak that the State Attorney General's chambers are committed and relentless in our due and fair administration of the law, and will continue to work diligently and assiduously in meeting the expectations of the Rakyat of Sarawak. Close cooperation with the judiciary. The State Attorney General's Chambers is always keen to maintain a close working relationship with the judiciary. I'm proud that our chambers have participated and contributed together with the judiciary in finalizing the sentencing guidelines for violent crimes, which was launched on the 16th of June 2022. I wish to also say thank you to Yang Ahmad Arif, the Chief Justice of Malaysia, for previously facilitating discussions and settlement of matters under Majlis Khas MA 63, which relate to Sarawak and the judiciary. I would like to take this opportunity, if it is not too late, to officially congratulate on your appointment as the acting President of the Court of Appeal, as well as Yang Ahmad Arif, Datuk Muhammad Zabidin Muhammadiyah, on your appointment as the acting Chief Judge of Malaya. Finally, on behalf of my esteemed colleagues in the State Attorney General's Chambers, I wish Yang Ahmad Arif, honorable members of the bench and members of the bar, a very happy new year, good health, and every success in the year 2023. And to our Chinese brothers and sisters in the legal fraternity, Kong Hei Fat Chai. I'm very much obliged, my lord, my lady, my lords.
I now invite Yang Berbahagia to deliver her speech.
Very good morning, everyone. Salam perpaduan, salam Sabah Maju Jaya. The Right Honourable Tun Tengku Maimun binti Tuan Mat, the Chief Justice, the Honourable Tun Muhammad Raus Sharif, former Chief Justice of Malaysia, and members of the Judicial Appointment Commission, the Right Honourable Tan Sri Dato' Amar Abang Iskandar bin Abang Hashim, the Chief Judge of Sabah and Sarawak and Acting President, Court of Appeal, the Honourable Dato' Muhammad Zabidi Muhammadiyah, Federal Court Judge and Acting Chief Judge of Malaya, the Honourable Deputy Minister in Prime Minister Department, Law and Institutional Reforms, Honourable Members of Judicial Appointment Commission, Honourable Brothers and Sister Judges of Federal Court, Court of Appeal, High Court and Judicial Commissioner, the Honourable Solicitor General I of Malaysia, the Honourable Senior State Attorney of the Attorney General of Sarawak, President of Malaysia Bar, the Sabah Law Society, the Advocate Association of Sarawak, and representative from the Law Society of Brunei Darussalam, head and representative from the federal and state departments and agencies, representative from the U.S. Department of Justice and the United Nations Development Programme, judicial and legal officers, members of the bar, members of the media, legal publisher, distinguished guests, ladies and gentlemen. It is a great honor and pleasure for me to be standing here this morning. I would like to express my deepest gratitude to the organizing committee for a warm welcome of the opening legal year 2023 of Sabah and Sarawak. Like every opening legal year tradition, let me now very quickly share some of our achievements from the past year up until now. In other words, allow me to budge a little. Do not worry. I will keep my speech as short as concise as possible. So I see smile faces then. This speech will focus on two parts. Firstly, regarding the establishment of new enforcement unit in our Sabah AG chambers. And secondly, some accomplishment we have done under the Malaysian Agreement 1963. My ladies, my lord, let me now proceed to the first part of my speech. Last year, the Sabah State Cabinet has approved the establishment of new enforcement of the prosecution unit in the Sabah State AG chambers. Many of our enactments and ordinances contains provision which allow the state to prosecute any individual or entity which has committed an offense provided under the state enactments or ordinances. As of today, there are approximately 42 criminal offenses provision within the state of Sabah enactment and ordinances. However, many of these provisions have remained untested until today. Since the power to conduct criminal proceeding matters lies with the federal government, the Deputy Public Prosecutor in Sabah are tasked with handling offences relating to both federal as well as Sabah state laws. These new units within the chambers is established with an intention to ease and share the burden of enforcement with the federal government, especially in respect of Sabah laws. During the process of implementation of the units, we will be able to highlight any of the state law which requires improvements, and once those have been identified, amendments to the respective provision will be carried out accordingly. Eventually, the establishment of the said unit is to set up a platform for conducting our own prosecution for any state law offences. Just very recently, we have received good news from the federal AG as 3 officers from our chambers will be appointed as TPP in due course. Once has taken place, this new unit will be formally set in motion. In that, I would like to extend my heartfelt gratitude to the federal AG. Thank you so much. As this is a new unit within our chambers, we look forward to work hand in hand with the federal AG as well as the court. My ladies and my lord, now on the second part of my speech. The State Attorney General Chambers had and will always continue to fight for Sabah rights under the Malaysian Agreement relating to Malaysian Agreement 1963, or we call it MA63, as aspired by the people of Sabah from the devolution of power exercised in 2016 to Special Council Committee relating to Malaysian Agreement 1963, or we call it Majlis Khas Perjanjian Malaysia 1963, which held last year and has become forum in discussing and resolving pertinent issue between federal government, the Sabah government, and the Sarawak government. Although there are still more to achieve, we hope that the new administration, our newly elected Prime Minister, Yang Amat Berhormat Datuk Sri Anwar Ibrahim, will continue the discussion and fulfill our claim as provided under the Malaysian Agreement. We take that the recent announcement of our PM is a sign of continued discussion and fulfillment of our rights as aspired by the people of Sabah. My ladies and my lords, last year we have achieved important milestone in our history, in that we have managed to restore our status in the Malaysia Agreement, where the Parliament had unanimously agreed to amend Article 1.2 and Article 160 sub 2 of the Federal Constitution, which gave new definition of the Federation. Besides that, the State Government of Sabah and Petronas has entered into Commercial Cooperation Agreement, or we call it CCA, on the 7th December 2021, in which it is the aspiration of the people of Sabah to get interest in the oil and gas industry. Through CCA, we had set up a consultative framework between Sabah and Petronas to discuss on any decision that is relating to the oil and gas industries in the state of Sabah. This includes giving opportunity as well as proper training to local Sabahan under vendor development program and participation within the petroleum industries in Sabah. With CCA, we had set up a Sabah Gas Master Plan, and recently on 9 January 2023, Sabah State Government through SMJ Sdn Bhd, a company wholly owned by the state government, had acquired 25% shareholding interest in the Petronas Chemical Fertilizer Sabah Sdn Bhd. Further, there are other matters achieved last year. For instance, empowerment regarding licensing and deep sea fishing is now within the control of the Sabah Fisheries Department. The full administrative control of the Sipadan Iligitan Island were also granted to the Sabah government, and the appointment of the Sabahan as a board members in the Inland Revenue Board. The Sabah State Attorney General Chambers with the state government of Sabah is committed to solve every other standing matters with the federal government. My ladies and my lords, of gas sector that are conducted can be controlled and implemented effectively and efficiently. The transfer of regulatory power to the gas to the Sabah government is one of the issues claimed under the MA63. My ladies and my lord, although I have mentioned in the beginning in this speech, short and concise, I think I have taken enough of your time. So let me end this speech by saying, on behalf of the Sabah State Government, Sabah State Attorney General Chambers, I would like to hereby declare that we will endeavor to provide a higher standard of excellence, fairness, and integrity in all our services to the government of the state of Sabah, May we all strive for excellence in our upcoming journey. Before I end my speech, I would also like to wish each and every one of you a Happy New Year, and let me deliver 2 poems in Sarawak dialect. Meli buah dabe, nyinggah di pasar Miri. Dabe Miri nyaman, rasanya nak lunak lagi. Pembukaan tahun perundangan 2023 di bulan Januari, segan tok jak pertemuan kita, semoga jumpa lagi. Sungai Miri airnya berseri, orang Miri cukup mereti. Kami Miri terima kasih, udang ngambat penatai engkau atik kasih. And also I would like to wish to those who celebrating Chinese New Year, Happy Chinese New Year in advance. Xin Ning Kuai Le, Kong Si Fa Chai. And thank you everyone.
I invite now Yang Berbahagia Datuk Ahmad Tariruddin bin Muhammad Saleh, Solicitor General 1, to deliver the speech of the Attorney General of Malaysia.
Very familiar faces, Yang Marif. May it please, Your Honor, the Right Honourable Tun Tengku Maimun bin Tuan Mat, the Chief Justice of Malaysia, the Honourable Tun Muhammad Raus Sharif, former Chief Justice of Sri Dato' Ahmad Abang Iskandar bin Abang Hashim, the Chief Judge of Sabah and Sarawak, and Acting President Court of Appeal, the Honourable Dato' Muhammad Zainuddin Maddiah, Acting Chief Judge of Malaya, the Honourable Deputy Minister of the Prime Minister's Department, Laws and National Reform, Honourable Members of the Judicial Appointment Commission, Honourable Judges of the Federal Court, Court of Appeal, High Court, and Judicial Commissioners, the Honourable State Attorney General of Sabah, and the Honourable Senior State Attorney General of Sarawak, President of the Advocate Association of Sarawak and Sabah Law Society, representative from the Nation Bar and Law Society of Brunei Darussalam, mayors of the city of Miri, heads and representative of the federal and state department, international organizations and agencies, judicial and legal officer, members of the bar, members of the media and ladies and legal publishers, distinguished guests, ladies and gentlemen. Assalamualaikum wabarakatuh, and a very good morning and salam sejahtera. On behalf of the Honourable the Attorney General of Malaysia, Yang Berbahagia Tan Sri Idrus Harum, allow me to first extend my heartfelt appreciation to the Malaysian judiciary for a warm welcome to the opening of the legal year Sabah and Sarawak 2023. However, due to unforeseen circumstances, Yang Berbahagia Tan Sri not able to attend this auspicious ceremony, I therefore relay his warm regards to everyone in attendance here today. Not to worry, my speech will be short and sweet. It is indeed an honor and privilege to be able to address your ladyship, your lordship, and distinguished guests in front of such a majestic alluring vista of Sarawak, land of the Hornbills. Not to forget, during my early years of service, I was a magistrate in Cebu, Sarawak, and I treasure all the memories and experience gained. It is a long-standing custom that as a new legal year begins, accomplishment and advancement that the justice system has made over the years. My ladies and my lords, following 6 decades of Merdeka, Malaysia saw her democracy develop in the preceding months. What may have appeared to be an impasse from a political perspective actually shows otherwise. The Attorney General Chambers, or known as AGC, played a crucial role in the constitutional development leading up to the 15 general elections, or GA15. We were directly involved in the drafting of the several constitutional amendments which have impacted the Malaysian electoral landscape. They include the implementation of the automatic registration of the Malaysian national who reach the age of 18 as electors. A strong government with competent arms is required. It is hoped that our democracy remain intact with the coming of the new government. Significant steps have lately been made demonstrating the tenacity and will of our government, especially on matters more pertinent to Sabah and Sarawak, namely the implementation of the Nation Agreement of 1963 or MA63. We were also involved in various negotiation and consultation between the federal and state government of Sabah and Sarawak under the then platform, the Special Council in Malaysia Agreement 1963 or Majlis Khas mengenai pelaksanaan Perjanjian Malaysia 1963 and its subcommittee. On this note, the AGC will continue to give unwavering support in seeing this matter through. My ladies and my lords, over the past years, we have gotten better at adjusting to and putting up with COVID-19. The advent of the new OBB variant has shown us how unpredictable life is, just as we were beginning to believe that the endemic may be over. The AGC has remained on course and has continued to provide legal support to the government. During these uncertainties, we embark on a new effort to change how we operate and how we conduct ourselves. To be more productive and efficient, we did not let the endemic slow us down. Considering the hype surrounding GA15 and the COVID-19 pandemic transition to an endemic stage, I'm humbled and gratified to see how diligent my officers were throughout this period of time. My officers have consistently carried out their duties and made an effort to uphold the law, particularly in challenging circumstances. We take pride in the following achievement for the year 2020, rendering legal opinion and advice on caretaker government and election matters. Operation of the AGC Bilik Gerakan Pilihan Raya throughout GA15 that acts as inter alia, a centralized repository for legal questions on elections and police reports related to election-related offences. Gazetting of 45 acts and 910 subsidiary legislations in the Federal Gazette managed by AGC through our in-house Federal Legislation Portal. Participation in the negotiation and in conclusion of 22 high-impact agreements involving highways as well as niche services at government strategic facilities. Involvement in high-profile cases, some of which are still pending and ongoing. And on international front, the AGC has been active in defending Malaysia's sovereignty, territorial, economic integrity, and in international legal dispute worldwide. Apart from that, thanks to the silver lining brought by COVID-19 pandemic, the legal community has now become digitally driven. Application of cutting-edge information and communication technologies is applied in many areas of the legal service, which now includes call to the bar event. The AGC is pleased to be part of this incredible evolution. We pledge to support this continuous effort in ICT development by ensuring our end and that our system be upgraded from time to time to be on par with the existing progress made. This is to prevent what the old adage said, justice delayed is justice denied. My ladies and my lords, separation of powers as Montesquieu suggested means cooperation and collaboration. I believe the coordination and collaboration must also come from the judiciary, AGC and the bar, the three main institutions that make up the legal system. The judiciary, AGC and the bar must collaborate to protect justice and the rule of law, since they are the custodian of the Constitution and the sentinel of the people. The assistance provided by the Yayasan Bantuan Guaman Kebangsaan YBGK in ensuring fundamental access to justice serves as a typical illustration of close cooperation within the framework of our legal system. After 10 years of its establishment, the beginning of 2022 saw a tremendous improvement in the accessibility of YBGK. As a result, an increase of 13% in the number of cases represented by YBGK was recorded. I would like to reiterate what the Attorney General said during his Oli speech 2023. It must be emphasized that the government's fund is not able to sustain the operation of YBGK, especially on the claims and payment to the devoted lawyers, who have largely contributed to such services, even though year 2020 has seen the biggest contribution for YBGK fund from the governments. Hence, there is a need to secure other sources of financing to achieve the objective of YBGK. As a way forward, it is hoped all counterparts to YBGK will continue to give their unequivocal support, especially in terms of financial funding as agreed in 2011. In order to sustain the operation of YBGK in years to come, I extend the AGC many thanks for the support given in near future. With that in mind, I would like to conclude by wishing a good year to everyone in the legal community, as well as those in the attendance today. Maybe we'll be able to anticipate a year that is more tranquil and harmonious. As my final parting word, I'm not going to recite pantun, Yang Arif. Let us cherish a beautiful verse from The Pioneers of Pioneers by Walt Whitman. All the past we leave behind, we debouch upon a new, mightier, and varied world. Fresh and strong, the world we seize, the world of labor and the march, pioneers of pioneers. With that in mind, I end my speech with Wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh. I'm obliged, Yang Arif.
The Honorable Deputy Minister in charge of law and institutional reforms, Yang Berhormat Ram Kapal Singh, anak lelaki Kapal Singh. The Honorable Members of the Judicial Appointments Commission, Honorable Brother and Sister Judges of the Federal Court, the Court of Appeal, the High Court, and Judicial Commissioners. The Honorable Solicitor General 1 of Malaysia, the Honorable State Attorney General of Sabah, and the Deputy State Attorney General of Sarawak, Presidents of the Malaysian Bar, Sabah Law Society, and Advocates Association of Sarawak, and their representative from the Law Society of Brunei Darussalam, Mayor of the MIRI City Council, heads and representatives of the federal and state departments and agencies, representations development program, UNDP, judicial and legal officers, members of the bar, members of the media, legal publishers, distinguished guests, ladies and gentlemen. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning. Selamat datang against the COVID-19 pandemic. The previous Oli was held in a hybrid manner, with most guests having to attend virtually via video conferencing. I'm glad that we have passed we have moved past that. I thank the Solicitor General, the State Attorney Generals of Sabah and Sarawak, and the Presidents of the Advocates Association of Sabah and Sarawak Society, respectively, for their respective speeches. I applaud your achievements for the past year. I look forward to our continued cooperation to expand effective access to justice. If I may also make a brief narration of the happenings in the past year, 2022, for the High Court in Sabah and Sarawak. Last year, 61% out of 840 registered criminal cases. These numbers include cases carried forward from previous years, which also applies to all courts that I will mention later. Whereas in the High Court of Sarawak, it has disposed 50% out of 8,349 registered civil cases and 289 cases out of 1,259 registered criminal cases. Out of 2,529 registered civil cases in Sessions Court of Sabah, 67% were disposed of last year. As for criminal cases in Sessions Court in Sabah, 78% out of 4,595 registered cases were disposed. 63% out of 2,702 civil cases were disposed of in the Sessions Court, while at 85% out of 3,962 criminal cases were disposed of. The Magistrates Court of Sabah disposed of 81% out of 12,542 civil cases and 80% out of 73,231 criminal cases in 2022. The Magistrates Court in Sarawak, on the other hand, 81% out of 7,489 civil cases and 92% out of 47,168 criminal cases in 2022. The year 2022 also saw the lifting of stiff COVID-19 restrictions, which had allowed us to come together after 2 years of self-isolation and virtual meetups. The Sarawak Court Working Group on Environment, SWGE, and the Kota Kinabalu Court Working Group on Environment were fortunate to have been able to organize a number of events together with the WWF Malaysia. I wish to highlight a few crimes. Immediately after the launching, the SWGE took part in the conservation program at Bung Beratak Heritage Center. Activities include briefing on the history of the Bung Beratak Heritage Center and planting of trees. In an effort to foster and inspire conservational spirit within the judicial community, the Aram Ngabas Guai Kame, Let's Visit Our Caves program was launched on the 27th of November with the visit by SWGE members to Gua Silabur, Serian. The KKWGE also had organized a number of events, namely the 1 hour for nature with WWF, seminar on environmental conservation and enforcement in Sabah, protecting natural heritage with the Sabah Parks, and the second Borneo Colloquium on environmental justice in collaboration with WWF and SLS. As a fast-growing and emerging and developing country, our aim in the judiciary has always been to deliver a world-class modern justice system that is independent, effective, responsive, efficient, pioneering, and one that staunchly upholds the rule of law. As most of you are aware, the digitalization of the Sabah and Sarawak court started more than a decade ago. Today, we continue to introduce disruptive technologies into our justice system in order to be future-ready. Our artificial intelligence in court sentencing, ICOS, system continues to be fed with sentencing data for offences under subsection 12(2) of the Dangerous Drugs Act 1952, and will also be implemented for offences under the section 380 of the Penal Code within the year, while its counterpart intended for personal injury claims is in the works. The redevelopment of the Integrated Court System, ICS, is also well underway through the E-Kehakiman Sabah Sarawak EKSS project. Throughout the year 2022, a majority of courthouses in Sabah and Sarawak have undergone a digital makeover with the installation of new hardware and software for the court recording transcription system, or the CRT. We strive to provide safe, secure, and convenient facilities and amenities for our stakeholders. We take note that facilities that are out of order in some courthouses, particularly the air conditioning system in the Kuching Court Complex, as was highlighted by Mr. Gurvir just now. Rest assured that repair works are underway, and we will continue to work working to refurbish, repair, and replace these facilities. After all, we are also, the court staff are also the end users of these facilities. We have as well integrated the e-court finance ECF system in an effort to digitalize monetary transactions in courts. These are all necessary accompaniments in order for the judiciary to deliver efficient service to members of the public and our stakeholders. As part of our efforts to improve access to justice, we also have been carrying on the service of the mobile court program with support from members of the bar, related government departments, and NGOs. We are also committed to equipping members of the judiciary with the right tools for the profession. A substantial number of monthly and bi-monthly judicial capacity building programs have been the judicial officers. These include the monthly Judicial Community Forum, the seminar on contempt of court, and more. In essence, the judges and judicial commissioners here in Sabah and Sarawak share their knowledge with the officers in an interactive environment. All of these measures, especially the introduction of disruptive technologies, must of course be in line with the concept of open justice and judicial independence. Open justice refers to the accessibility to judicial proceedings by the public. Accessibility in this context includes allowing the public to observe trials as they happen in the real time and allowing public access to records of the trial proceedings. This concept promotes transparency and would inspire public confidence in the judiciary. As aptly put by the revered philosopher Jeremy Bentham, who said, "Where there is no publicity, there is no justice. Publicity is the goal of justice. It is the keenest spur to exertion and the surest of all guards against improbity." On the other hand, judicial independence refers to the concept that the judiciary must be able to exercise its function in accordance with the rule of law without any interference, be it extrinsic or intrinsic. Both concepts are pivotal to the protecting democracy and the integrity of the judiciary. As the conduit through which the information on judicial proceedings are passed to the general public, the media plays a vital role to ensure that both these concepts are properly observed. Against this backdrop, I echo the sentiments expressed by my learned sister judge, the Right Honorable Chief Justice of Malaysia, at the recent opening of the legal year 2023 per session in Putrajaya, when her ladyship said, and I quote, "We just write our documents to keep the public abreast and not to seek validation from the public or from any other quarters. Judicial independence will not be compromised as long as cases are decided without fear or ill motive, without any external or internal pressure, and without regard to personalities. Unquote. Conclusion. Distinguished guests, all of you are important stakeholders in our long and maybe winding road to deliver effective, responsive, and efficient judicial service. I hope that we could share this vision together as we strive to embrace changes and to keep ourselves abreast with time. In ushering the new legal year 2023, allow me to take this opportunity to thank all of you for your cooperation and camaraderie in upholding the rule of law as officers of the court, regardless of your role, be it as counsel, as a judge, or court staff. We look forward to your steadfast cooperation and continued support in this new legal year in discharging our role to dispense justice to our various stakeholders. I would like to thank the organizing committee for this year's OLI, led by the Registrar of the Court of Sabah Sarawak, for the efforts and endeavors. I also wish to especially thank Yang Arif, Tuan Din Wen, Delhi, and the resident High Court of MIRI, and Dato' Hasbi binti Hassan, our Chief Registrar of the Federal Court, for their contributions in ensuring that these events are well coordinated and executed. Let us walk into the year 2023 with renewed strength, vigor, and commitment to the rule of law. Yang Arif Tun, may I speech with two pantuns. Gunung Kinabalu megah berdiri, lambang kemegahan Ibu Pertiwi. Tahun baharu penuh aspirasi, akses keadilan perlu ditepati. Sungai Rojang terus berbudi, kenyalang tinggi di awan biru. Sabah Sarawak sentiasa di hati, aman makmur terus maju. I now therefore declare open the legal year for Sabah and Sarawak 2023. This is the history of all the OLIs since the beginning.
adjourned. Nervous ah. Duduk ni. Tak ada kasi semua terima. Tak ada.